Good afternoon, everyone. Thank you for joining our webinar today. I am Emma Waldron, WCVA's Risk, Procurement and Governance Manager, and I'm also WCVA's Data Protection Officer. This is our final webinar of the GDPR Desktop Data Series, and with only 1 month to go, we will be recapping on the key areas that charities should have covered ahead of GDPR. Our speaker is Bethan Bonsall from the Information Commissioner's Office. Welcome, Bethan.
Hi.
So Bethan is the ICO's lead policy officer, and she is with us today to hopefully answer any questions or concerns that you may wish to raise. We anticipate today's session will take between half an hour and 45 minutes, depending on questions. And please feel free to add any questions to the chat pane during the session, and we'll aim to answer them. There will also be an opportunity to share your comments by completing a short survey, which we will share the details of on the final slide. Okay, over to you, Bethan.
Thanks, Emma, and thanks to you all for joining us for our 12th and final webinar under the Desktop Data Series. So today's webinar is more of a blank slate than previous webinars have been, because I thought it was a good opportunity to look at some of the areas that we've not covered in detail in previous sessions, and also an opportunity to ask questions as we go along. So I thought it would be useful if we pause at the end of every section to take 2 or 3 questions and then move along. So we'll see how that goes depending on time. If time is pressing on, we'll move on and take questions again at the end. But please also remember that our office is here to help. So any questions you don't get to ask today, you can always ask us at a later date. So to start off with, I thought we'd have a little look at the principles of the General Data Protection Regulation to get us off to a nice broad start, because I don't think we've covered these in any great detail throughout the 11 previous webinars. So like the Data Protection Act, the GDPR is principle-based. The principles look similar to the 8 that we see in the Data Protection Act, with some added detail. So let's take a look at those in more detail now. The first principle states that personal data must be processed fairly, lawfully, and transparently. And that addition of transparently is a new addition compared to Principle 1 of the current DPA, and it links strongly to the right to be informed. So it basically means that you as charities must be transparent as well as fair and lawful when you're using personal data. Principle B links back to transparency and legality, so you must have a legal basis for processing data, and you need to explain to people what that is. The personal data you process must be adequate for the job you specified to individuals. It must be relevant to that job and also limited to what's necessary in order to get that job done. So this one's all about the quality of the information that you're collecting. Data must be accurate, so you need to have a suitable system for checking your data at appropriate intervals. So how often you make accuracy checks will really depend on your purpose and how critical the data is to the rights and freedoms of data subjects. Where you no longer need the data in an identifiable form, either anonymise or pseudonymise that data. If you don't need it at all, then securely destroy it. So this principle really does strongly require your charity to have a robust retention policy in place. If you're holding on to personal data for too long, you're likely to be in breach of other principles. So for example, it might not be fair to individuals, and the quality of the data will decrease if you're keeping it for longer than you need to, as it's likely to be inaccurate and no longer fit for purpose. So the quality of the data is kind of degrading as you go along. And Principle F, very much like the data protection security principle, the GDPR requires you to take appropriate technical and organisational measures to ensure security, including protection against unauthorised or unlawful processing, and also against accidental loss, destruction or damage to that data. So it's not just about physical and technical security measures here. Building a strong culture of data protection awareness within your charity will also be key. So policies, procedures and staff training will be essential to building this culture of data protection awareness. And as you can see on the right hand side, GDPR also introduces a new principle of accountability. So the controller, so yourselves as charities, must be able to demonstrate how you comply with all of the principles that we see on the left-hand side. There are a number of ways to demonstrate accountability under the GDPR, such as appointing a data protection officer when required, and carrying out data protection impact assessments when the GDPR calls for these to be undertaken. Our webinar on privacy by design from last year will be really useful for those who were unable to attend. But please note that we've also recently gone out to consultation on our data protection impact assessment guidance. So although the consultation is now closed, the draft document can still be found on our website and is a really useful read. So that's a kind of whistle-stop tour of the principles of the GDPR. So many of you that work with data protection will realise that a lot of those principles are almost identical to the current principles that we've got under the existing data protection regime. So I thought it would be useful if we pause just to see if anyone's got any questions on this slide. And if not, we can move along to the next section then. So feel free to ask any that you've got on this slide in particular, or about anything else, and I'll let you know if we're going to be covering it later on or whether I can answer it now.
Okay, so whilst we're waiting for questions, I do have a question, Bethan, which is, when is a data protection officer required?
Okay, so not all organisations will be required to appoint a data protection officer. It's important to note that even if you're not required, you can still do so on a voluntary basis. So public authorities will all definitely need to appoint a data protection officer. Any organisations doing kind of large-scale monitoring of individuals, so that could be online behaviour tracking, etc. And also organisations that find themselves doing large-scale kind of processing of special category data. So by special category data, we mean information that's more sensitive in nature. I would say that if you're in the position where you've not determined whether you do or don't need a data protection officer, have a look at our website, because we link to guidance there, not just from an ICO perspective, but also to a piece of guidance from the Article 29 Working Party, which is guidance that comes from a European level, and that guidance really does a good job of unpicking terms such as what we mean by large-scale monitoring, etc. So if you haven't decided whether you need to appoint a data protection officer within your charity, then certainly now is the time to do so while you've still got a month to go. If you decide that you don't need a data protection officer, then it's really important that you document that decision, because that shows accountability. That shows that you've thought about whether you need one or not. And if you document that decision and someone complains about your charity not appointing one where you should have, then the fact that you've actually looked at that guidance and determined whether or not you don't need one will take you a long way compared to a charity that hasn't paid any regard to the fact that they may need to appoint a data protection officer.
Okay, thanks very much, Bethan. So there are no questions at the moment. Obviously, if you do have questions as Bethan's talking, please type them into the chat pane.
Thanks, Emma. So now that we've looked at the principles, I thought we'd cover some of the misinformation that does surround GDPR. So it strikes me that over the past 2 years, when I've been going out and about and doing kind of awareness raising sessions, much of the scaremongering that does exist around GDPR relates to the common myths that we often hear. So I thought it would be useful to address a couple of these myths to hopefully reassure those of you listening. So one myth has been that you must have consent to process all personal data that you as a charity hold, or you as any organisation holds. It's quite scary how much this buy-in how much buy-in this myth has had. I remember I think it was about a year ago, during one event that I was speaking at, we were asked how the security services, for example, would cope if they had to seek consent from every individual that they were investigating. So I think it's kind of clear to say that consent isn't the only option. But to address this myth, it's really important for everyone to remember that there are 6 legal bases for processing personal data, and consent is just one of those 6 options. So if you're processing special category data, so that kind of more sensitive information, you need to identify both a lawful basis for general processing and an additional basis for processing more sensitive data. But for now, just for this slide's sake, we'll focus solely on normal personal data, so nothing sensitive, and we'll look at the legal basis available in Article 6 of the GDPR. So it's also important to note that the requirement to have a legal basis for processing personal data isn't new. Organisations have always needed to meet what we call a condition for processing under the current Data Protection Act, and just like the GDPR, consent was one of those 6 options under the existing DPA. So we won't go through these in detail, but the 6 legal bases available for processing personal data under the GDPR are the ones that you can see on your screen. It's really important for you to determine your lawful basis before you begin processing data, and you should actually document that basis as well. Take care to get the legal basis right the first time, because you shouldn't swap to a different lawful basis at a later date without good reason. Your privacy notice should include reference to your lawful basis for processing, as well as the purposes of the processing. So it is really important, it's essential that you do know what your basis is for certain areas of processing. You can find out more information about privacy notices in the webinar that we ran in August 2017, and that was called Privacy Notices and Consent, and also by referring to our guide to GDPR on the ICO's website, so in particular the section on the right to be informed. So if we pause there after looking at legal basis, we're going to talk a bit about consent in a moment actually. So what I'll do is I'll go on to talk a bit more about consent, and then we can take any questions about legal basis in general. So let's have a little reality check. Consent should be chosen as your legal basis if none of the other bases apply to your processing, and also in some circumstances where you're using someone's data for the purposes of electronic marketing, so things like email and text, where you're sending direct marketing messages. Now, that's because the Privacy and Electronic Communication regulations apply to electronic marketing, so that regulation needs to be read side by side alongside GDPR. So if any charities listening today do any direct marketing by electronic means, then certainly have a look at our guide to direct marketing, and also the webinar we ran in September 2017 about your obligations under the Privacy and Electronic Communication regulation. So I can't stress enough how important that guide to direct marketing is, because it's not a new requirement, it's been around since 2003, so please do have a read of it if you're embarking on any kind of major marketing campaigns. It's really important to note that GDPR does raise the standard for what constitutes valid consent. So under GDPR, consent has to be freely given, specific, informed, and it's got to be an unambiguous indication of the wishes of the individual. There's got to be a clear affirmative action, which means that silence or pre-ticked boxes or any other kind of inactivity can't constitute valid consent. The request for consent must be clear, prominent, and also separate from accepting general terms and conditions. Organisations will find it harder to make consent a condition of signing up to a service because that won't meet the standard of being freely given under GDPR. And the burden of proof is on the data controller, so the charity, the organisation, who should keep a record of how and when consent was given. And it's also important to realise that consent under GDPR must also be as easy to withdraw consent as it was to give in the first place. So I think it's fair to say that all of these points really do emphasise the importance of relying on consent in areas where you truly can meet those standards that we've just looked at. So have a look at our consent guidance in our guide to the GDPR, which will be a really valuable kind of tool for those who haven't yet had a chance to read it. But the important thing is, look at where you're relying on consent at the moment as a charity, and work out whether A, there's another lawful basis that does apply, and if there's not another legal basis, so not one of those that applies on the screen before, then make sure that when you're relying on consent, you can meet the highest standard that GDPR brings about in order for you to rely on consent. So, bit of another whistle-stop tour through consent and other legal basis. Do we have any questions relating to what we've just discussed?
Okay, so I've got a question. Hopefully there are some questions coming in on the chat pane as well, but my question is regarding special category data, which you've mentioned a few times there. Could you just go into that in a bit more detail, please?
Yeah, certainly. Thanks, Emma. So special category data is information that's of a more sensitive nature, which is why you need an extra kind of hoop to jump through. So you don't just have to look at the Article 6 conditions, you also need to meet a condition in a further condition in Article 9 of the GDPR. So what we mean by special category data, you've got racial or ethnic origin information, political beliefs, religious beliefs, trade union membership, also genetic and biometric information as well in certain circumstances. But you've also got things like health information, so physical and or mental health, and also a bit about people's sex lives or sexual orientation. So looking at those kind of types of data, it really is clear to understand why information such as that would warrant that extra protection under GDPR. So that's a very good question.
Okay, thanks. And just to confirm, with biometric data and genetic data, that's new, isn't it, under GDPR?
So it's always been kind of personal data, but the kind of addition of those categories into the more special category data is new in GDPR.
And by biometrics, we mean fingerprints, facial recognition, voice recognition, etc.
Yeah, we do indeed.
Brilliant. Okay, so there's no more questions at the moment, so we'll carry on with the next slide then.
Yeah, thank you. So another myth that we're faced with, and I get faced with this quite often when I'm out and about, is that the ICO will be issuing huge fines for every single data breach that's reported to us as the regulator. So again, let's take a quick reality check and hopefully reassure everyone listening today. So the first point to note is that personal data breach reporting has a strong public policy purpose. The law is designed to push companies and public bodies to step up their ability to detect and deter breaches. So what's foremost in regulators' mind isn't to punish the organisations, but to make them better equipped to deal with security vulnerabilities in the future. The public need to have trust and confidence that the ICO is collecting and analysing information about breaches, looking for trends, patterns and wider issues with organisations, sectors or types of technologies as well. So it will help organisations get data protection right not just now, but also in the future. Another myth is that all personal data breaches will need to be reported to the ICO. So in actual fact, it's only those that are likely to result in a risk to people's rights and freedoms that need to be reported to us. So if it's unlikely that there's a risk to people's rights and freedoms from the personal data breach, you don't necessarily need to report it to the ICO. You'd still need to keep an internal record of any breaches that occur though. And you should also remember that those that do meet the threshold, so those breaches that do have the impact on rights and freedoms of individuals, need to be reported to the ICO within 72 hours. And it's important for me to add at that point that it's not just the data protection officer or whoever's responsible for data protection of within your charity being made aware. It's 72 hours from anyone detecting that breach has taken place. So it really is essential that in terms of staff training, all members of staff, regardless of their level, their kind of role, it's important that they know what to do in the event that they've been made aware of a data breach. So whether that's referring it to the data protection officer, their line manager, there's got to be a clear kind of level of accountability so that this 72-hour threshold can be met. The amount that the ICO can fine under the GDPR has increased significantly from the current £500,000 that we can fine under the DPA. The maximum under GDPR that we can fine will be €20 million or 4% of annual worldwide turnover. So I think it's fair to say that heavy fines for serious breaches really do reflect just how important personal data is in a 21st century world. But the ICO intends to use these powers proportionately and sensibly. And while fines may be the sledgehammer in the ICO's toolbox, we will still have access to lots of other tools that are well suited to the task at hand and just as effective. So for example, we can issue undertakings to organisations, which are kind of like agreements where the organisation commits to doing something. So for example, staff training. And we can also issue enforcement notices, which compel an organisation to take certain steps. So please remember that fines will most certainly not be issued in the case of every infringement that's reported to us as the regulator. So any questions on breach reporting or breaches in general? Are we happy with it's important that I should actually say that data breaches don't just mean that you've lost personal data. It could be a lack of access or availability. So your systems might have gone down and someone might need access to information quite urgently. It could be unauthorized access. So you might have someone from one department going into a HR file and looking at information that they really have no warrant to be looking at. So it's wider than just losing data. So really do brush up on the kind of data breach requirements if you haven't already done so, because it's going to be quite a significant area in terms of preparing for GDPR.
Okay, so we do have a question from Leslie, I think relating to the previous slides regarding consent. So how is consent gained by someone without capacity?
So there's a lot of kind of laws out there in terms of mental health capacity, etc., that would probably answer that question better than from an ICO perspective. I would probably look at to see whether consent would be met in terms of the additional, the kind of stricter GDPR requirements, or whether there was any other kind of legal basis that might stand up more than consent. But I'm mindful of answering that one too much because I know that there's a lot of other laws that you as charities will probably be aware of that kind of govern the capacity issue.
Okay, yeah, and just to remind you as well that there are other options other than consent with the other legal basis that can be relied on as well. Okay, hope that answered your question, Leslie. So we'll move on to the next slides.
Yeah. So we're almost at the end now, but just to kind of recap, I've mentioned a lot of useful resources throughout this webinar. I've referred back to previous desktop data webinars that we've done, but also a lot of guidance on the ICO's website. So let's just have a quick look at the tools that we as a regulator have to help you as charities, because we do understand it's a daunting time. It's a time, just to stress, that we are here to help you with. We've been doing these 12 webinars over the last year to try and equip you with the skills necessary to be prepared for GDPR next month. We've got dedicated pages on our website for charities, so if you haven't had a look at those, then I really would recommend that you do. We've also got self-assessment toolkits that are aimed for a whole wide range of sectors. So if you haven't had a chance to look at those toolkits and fill out any of the separate modules within that toolkit, I really would urge that you do that when you've got a few minutes, because those toolkits really do give you an idea of where your organisation's compliance is at present, and it also kind of points to areas where you can really build on that compliance. So we recommend guidance. If you've answered poorly on some areas, we'll signpost you to the right tools, resources and guidance that we've got as a regulator to help you kind of fill in those gaps. We've also got a national helpline, and our office in Wales is always happy to help with queries. So you've got the helpline number starting with 0303, and we've also got the Wales office number on the screen and our our email address as well. So if you haven't had contact with us before, we're not a scary regulator. We'd much rather you pick up the phone, run something past us, and we're here to help. So basically, don't feel that you have to kind of bury your head in the sand. If you've got an urgent data protection query, give us a ring. We are independent, so we can't tell you what to do. We can't say yes or no in a lot of circumstances, but we're here to kind of help you through this time. And just remember as well that a lot of GDPR isn't new. It's simply an extension of your current data protection requirements. So for those charities dialing in today that have a good grasp on data protection as it stands, you'll find yourself in a much nicer place come, a month's time, come 25th of May next month. Because as I said, a lot of it isn't new. It's just an extension of what might have been good practice under the current law being kind of brought into formal law. And finally, if you haven't already done so, subscribe to our newsletter, because that allows you to receive up-to-date guidance and news from us. And also, when our Wales office does do events across the country, we do tend to kind of put those into the newsletter where we're advertising spaces, etc. So over to you, Emma, if that's okay. I just want to, before we do finish, want to thank everyone for listening today. I really do hope that you found not just today's webinar useful, and hopefully you'll find the questions now useful as well, but I also hope that the previous 11 webinars have also served some purpose in helping you feel more equipped in terms of GDPR. I would also like to thank Emma, Kath and Leela at WCVA, because all of their hard work has really been appreciated, not just doing the organisation, but bearing with my lack of technical availability when I cancel webinars by accident when I move slides and press stop recording, etc. So thanks to you three, and thanks to you all. So over to Emma for any questions if we've got any.
Thank you very much, Bethan. Okay, so obviously with 1 month to go, we have, we're quite privileged to have Bethan here. So please do type in any questions relating to any aspect at all of GDPR into the chat pane. We do have a question there from Sharon. So we will need to review our consents for using photographs of children and families for promotional materials, social media, etc. Is there specific guidance to help with this?
Thanks for that question. That's quite a common question, actually, and it's one that we haven't got a dedicated page to address the issue of consent and photos for promotional materials. The key thing to remember is with photos, if it identifies an individual, then it's their personal data, so GDPR comes into scope. If you're relying on consent as your basis for taking photos, then it really is key that when you're telling people what's going to happen to those, you're being as informed and kind of unambiguous as you possibly can be. So if, for example, you know that you're going to take a photo at an event, but you're also hoping to use that in a wider publication, then make people aware that that photo is going to be used in certain scenarios, rather than just saying, do you consent to this photo being taken today? and then 2 months down the line, that individual suddenly realises that their photo has been used in a wider magazine, for example. So there's nothing, GDPR doesn't stop you from taking photos for publications, etc., but it's all about how informed that individual is. And if an individual is informed and they've got a greater kind of expectation about what's going to happen to their data, the more likely it is that that information will be processed fairly.
Okay, great. Hopefully that has answered your question, Sharon. And I believe my colleague has replied regarding the slides will be shared following this session. Question then from Charles. So where a council has outsourced work to a charity that was previously carried out by adult services, on what lawful basis is the charity processing the data it receives from the council about the service users? Does it make any difference if the service provided is statutory?
Okay, so we can't say what legal basis that would be, because that would be up to the organisations involved to map out what that basis would be. In terms of the data processor controller relationship, I'd have a look at our data controller guidance, and particularly the guidance document called Data Controllers and Processors, Determining the Differences, because it really is important ahead of GDPR, and we've covered this in our previous webinar on contracts and liabilities. It's really essential that you do know what hat you're wearing in relation to the processing. So if you're a charity and you're doing any kind of processing on behalf of another organisation, then it's really essential that you've mapped out that relationship ahead of GDPR, because what happens under GDPR is that the kind of responsibilities and liabilities increase for a data processor. So it's not one that I can give a yes or no answer to, I'm afraid, because we need to know a lot more detail, and it would be for the organisations involved to kind of establish what their basis would be. But the data controller processor guidance would be a useful starting point for you, and also our contracts and liabilities guidance as well on our website.
Yeah, and also just to add to that as well, it is possible that there's more than one data controller as well. So could be joint data controllers or data controllers in common. So
definitely have a look at that guidance and map out that relationship ahead of GDPR before the law changes.
Okay, so a question from Sue. Is all the other information contained in the other 11 webinars? Well, I'm not sure that we would capture absolutely everything, but there are certainly webinars specifically focusing on different areas such as consent, such as CCTV,
subject access requests.
Yeah, marketing.
A whole wide range. But like Emma said, it's probably impossible to cover every aspect of GDPR in those 11 webinars. So I would really urge you to look at our guide to GDPR. It can be quite a long read, but the ICO is very good at making guidance kind of easily digestible. So have a look on our website. Any areas that you're not sure about, if you want a bit more advice about them, please feel free to phone that number on your screen, so the 02920 number, because that will take you to our Wales office. And if we're around, then we would be more than happy to talk about any areas in more detail with you.
Okay, so hopefully that's answered your question, Sue. Down to Alana's question. Personal information has to be stored for longer than normal for safeguarding. How can this be reconciled with the right to be forgotten?
That's a good question, because that is kind of another myth that we're often faced with, in that the right to be forgotten is absolute across all kind of areas of personal data. So if an organisation received a request to be forgotten, so a request for erasure, but they had a very strong legitimate reason for keeping hold of that data, so for example for safeguarding purposes, then it doesn't mean that they have to delete that information and honour that request. You'd still have to get back to that individual, but in every single request that you do receive under GDPR, whether it's a request for erasure, a subject access request, a right to rectification request, always look at our guidance and see how that ties in with the request that you're faced with, because none of these rights, few of these rights will be blanket, particularly the right to erasure. The right to erasure is absolute if you're relying on consent, which really does link back to the point of making sure that you're not relying on consent in areas where another legal basis would apply, and that if someone asked for you to erase their data, then you could switch to another legal basis for processing. So it is really key that ahead of GDPR, you've mapped out not only what information you hold, but what your kind of legal basis is for that data, and you need to be sure that you've identified the most appropriate legal basis.
Thanks, Bethan. Hopefully that's helped, Alana. So down to Sarah and Joe. Is there a standard for storing data, e.g. cloud / some kind of encryption standards? How do you source encryption?
Okay, so this is more to do with the security of the information, so it's a good question. The security principle, so when we looked at that a few slides ago, it says that you must process information securely. Now, it really does depend, and it does require you to take a risk assessment in terms of the nature of the data that you're storing. If you've got data that's, names and addresses, etc., in some contexts you might have kind of less strict security than you would if you've got health information, for example. So that's two kind of very broad examples, but there's no kind of blanket standard for storing data. We've got a really good piece of guidance called IT security. I think it's for smaller businesses, but if you have a look on our charity pages, I think we do link to that there. And it goes into a bit more detail about, types of encryption standards that are available. We're unable to kind of recommend any type of encryption over the other, especially in terms of encryption providers, because again, we have to kind of maintain that independence. But certainly some types of data, so special category data, especially if you're taking laptops out and about, then devices like that would definitely need to be encrypted. The same for things like USB devices. If you've got a really easy little device that you can take personal data out of the office with, then things like that do need to be encrypted just to give that extra level of security for that data.
Thank you, Bethan. Okay, and question from Andy. Going back to photos at events, is it sufficient to explain to attendees what any photos may be used for, and to ask whether anybody wants to be kept out of photos? Or does every individual in a photo have to be given written consent? Is legitimate interest likely to be a relevant legal basis instead?
So again, this is one that we're asked quite often. Ultimately, there's no kind of right legal basis on a blanket basis. So every organisation will have to look at the context that they're taking photos in and work out whether consent or perhaps legitimate interest might suffice. An example would be at the WCVA conference in, was it March? I think it was March. There was a photographer at that event. There was about 600 delegates. There was, huge number of people. I was speaking at an event and a photographer walked in halfway to take photos. Something like that wouldn't be done on the basis of consent, because to actually get that positive affirmative action would probably be quite impossible to then work out who had said yes, who had said no, have I got a written kind of confirmation that someone said yes or no. So legitimate interest might stand up for some kind of context, but then in other areas you might really easily be able to go down the consent route, particularly for those photos involving children perhaps, where you might want to be extra careful. So schools almost always go for consent at the start of a term if they're going to use school photos for newsletters, for Twitter, etc. So legitimate interest could be a possibility, but you've always got to be careful with legitimate interest, that you're not just saying that you've got a legitimate interest and that's that. You've got to always make an assessment about what you're trying to pursue as a charity or an organisation and balance that against the fundamental rights to privacy that individuals have. So it's not just enough to say you're interested in doing something, so I'm going to run and do it. You've got to make sure that you're always documenting that you've made that assessment as per the legitimate interest balancing exercise would require.
And I think as well at another webinar we talked about photos as well, and we were saying that you need to have the appropriate notices at the events as well, so that photos will be taken, and perhaps for attendees to know who to speak to if they don't want their photo to appear in publications, etc.
Yeah, good point.
Okay, so question from Sue. What is the difference between vital interests and legitimate interests, please?
That's a good question. So the vital interest condition that we saw a few slides ago under Article 6 of GDPR, that really is a matter of life and death. So that's the kind of condition where you need to share data or you need to do something with data to protect someone's vital interest. So it can't just be, I'm worried about this person, so I'm going to disclose this data, because there's other options to disclose data for kind of areas like that. The vital interest condition really is a matter of kind of life and death. Legitimate interest, I kind of just explained a bit about that in the previous question, but that's basically saying that you've got an interest to do something. You've got to make sure that that interest is legitimate. So in terms of your powers and the laws that set you up as a charity and govern you, you've got to make sure that what you're intending on doing is okay under those. But again, you've also got to always, in every instance where you're relying on legitimate interest, you've got to balance your interest against the fundamental rights to privacy that individuals or your data subjects have in relation to their data. The next question about what a public task is, it's probably worth reading the guidance on our website in terms of what types of organisations will be able to rely on a public task. But this is the kind of condition where a lot of public sector organisations will rely on. So the ICO, for example, a lot of our kind of regulatory functions would be captured by that public task example. But have a look at our guidance and it does flesh out the kind of areas where that public task condition can be relied on.
Okay, thank you, Bethan. So hopefully that has helped and your questions have been answered there. I can see that we have another question coming in at the moment, so we'll just wait a few seconds for that question to come in. No pressure, Sarah and Joe. If anybody else has any questions as well, please type them in, because I think if this may be the last question, and then we'll end today's session. So I'll just give it a few more seconds.
And don't forget that those 11 webinars that we've already done are all on the WCVA's website, so certainly worth a look if you missed any.
Okay, so thanks, Sarah and Joe. Does the equipment that you use have to be for the sole purpose of the business? E.g., if a trainer takes photos on a phone, does it have to be their company's phone, or can they use their personal phone?
Okay, so a lot of organisations do allow staff members to use their own personal devices for work purposes. If you are going to allow that, then it's absolutely essential that you've got some sort of bring your own device guidance or policy out there so that staff know what the rules are governing the use of their own devices. It's an additional risk, because if you're allowing people to use their own personal devices, then what happens if that individual loses that phone that's not afforded the kind of same protection as your company issued devices might afford that data? So have a policy in place if it is something that you choose to do. It's not to say that GDPR is stopping you from doing that, but you're just opening yourself up to slightly more risk. So you definitely need to have a policy in place to back the use of personal devices up, because, you know, an individual needs to know what to do if they lose their phone. They don't only have to, you know, worry about a personal capacity. If they've lost a device that, for example, hasn't been password protected, what happens about all the company data that they've got and the personal data belonging to the charity and other kind of organisations that they might have on that phone?
So on that note then, Bethan, is there any sort of guidance on the ICO website, like bring your own device guidance?
There is. The bring your own device, I think it's cleverly named bring your own device guidance. But if you type in BYOD to the ICO search box on our website, then you will find it there. But it's I can't remember how long it is, but it's a really kind of useful read, and it does, you know, it emphasises the importance of saying, you know, it's not to stop you from doing this, but if you are going to allow staff to use their own devices, then have a policy to back that up, just so that staff members know what it is that they can and can't do with data on their own devices.
Okay, great. Thanks, Bethan. So there are no more questions in the chat pane. So we hope that you've all found these GDPR desktop data series sessions useful. Obviously, next month is when the new regulations come into effect. So as you can see, there is a link in the chat pane there. All the previous webinars are available on WCVA's website for you to look at any point, and also would encourage you to share the webinars with your colleagues and anyone that may find it useful. We'd also like to take this opportunity to thank the Information Commissioner's Office for working with WCVA to help the third sector in Wales prepare for GDPR, and especially to Bethan Bonsall for presenting the monthly sessions, and her colleague Helen Thomas who delivered Subject Access Request webinar in October. We really appreciate it, Bethan. You know, it's been 11 months, 12 months of webinars.
I think you're all sick of my voice by now, so
we will miss you next month.
Thank you, and thanks to you as well.
And a big thank you to everybody who signed up and joined us on the journey preparing for GDPR.